representing A6, that is the late Honorable Ssegirinya. Who unfortunately passed away. May Allah rest his soul in eternal peace. I pray that Council needs a brief scout in that respect before we proceed.
I'm obliged, my lord. The position on the 9th date of January. 9th January 2025. Our client, now the late Honorable Ssegirinya, passed on and was buried on the 11th day. And that would discharge our instructions, terminate our instructions, especially Alaka and company advocates. Main instructions were A6, but we had joint instructions. No, we had joint instructions, A5 and A6, but the main instruction for Alaka and company advocates was with A6. Our colleagues from the Kwago and company advocates, we had joint instructions with our colleagues from the Kwago and company advocates. And what remains, the instructions in A5, the Honorable Alan Ssegirinya. So I have also a brief to put my colleagues in record, that I'm also holding a brief for Council Prosecution.
Okay, then I get to Mr.
Yes.
Alaka and company advocates were representing
Patience that this court had with us at all times when our client was ill. Let the world know on record that we often in times prayed for the deceased Honorable Ssegirinya before commencement of the proceedings. And I think we don't take that for granted. And we appreciate, in the circumstances, the state needs to guide us on how to proceed, because then we are no longer supposed to be part of this proceeding in that respect. It is very clear that the deceased Honorable Ssegirinya, all the particulars was in all respects to accused person with A5. And we believe we cannot proceed with the indictment in the shape, in its current shape. So we need to be advised on how to proceed, the instructions of A5.
My Lord, Council having confirmed the date as state, as prosecution, as office of the DPP, we also condole with the family and friends and the people of Kawempe North constituency are those of Honorable Mohammed Ssegirinya. And we pray that his soul rests in eternal peace, and we shall miss him. My Lord, in respect to how we shall proceed, we need to, prosecution intends to make some amendments. In the indictment to reflect the current state of affairs. Because all cases against Honorable Ssegirinya are bet automatically. So we want to make some amendments to the current state of affairs, and that requires some time. Upon that background, my Lord, that we seek an adjournment. So pray, my Lord.
Your Honor, I wouldn't have any objection, save that I would strongly request this Honorable Court that is given a short time and compelled to abide by court's instructions, because Your Honor, this Honorable Court is aware that there are other co-accused persons who have been on remand and who have also equally lost loved ones while in cells. So this court should compel him to carry out the amendments so that this Honorable Court hears the matter for justice to prevail. That's my humble prayer.
The last time we appeared before this court, the matter was adjourned to today for further hearing of the matter. But unfortunately, the next time we've appeared, we have since lost our client, the Honorable Mohammed Ssegirinya. And it follows that as counsel we are to report, to give a report of the new developments, because upon demise of our client, the matter cannot continue with his name. It abates. So that report we came with today, unfortunately, the state was asking us for a death certificate as the proof of death. We were very clear, the Honorable Ssegirinya had an official burial, and that even the Electoral Commission actually did not ask for a death certificate before they went ahead to organize another election. So court took judicial notice of that, even in the absence of the death certificate on record, and confirmed that the Honorable Ssegirinya can no longer be part of these proceedings, and he has accordingly been struck off the list of the accused persons. The case has been terminated as against him. What remains is for the state to go and reorganize its file, amend its charges and indictment to remain the other co-accused persons, to see how we proceed with this matter. That includes on whether they actually still have a case upon discharging the Honorable Ssegirinya of this case, or if they believe they have no matters proceed with. This we shall know by the first date of April. And if they maintain the indictment with all the accused persons alive, then on the 8th we may have to proceed with the hearing of this matter. 7th and 8th of April we may proceed with the hearing of this matter.
Legally, what do you think when the one
As against that person, because you can't continue with a dead person, but it continues with the co-accused persons. But the implication is very key, especially in matters where there is a bit of conspiracy being talked about. The particulars of the offense in respect to the Honorable Ssegirinya and Honorable Alan Siwanyana were like conjoined twins. They were like twins, the particulars, that they jointly were at a given place and they did so and so together. So it becomes very complicated now that the Honorable Ssegirinya is no longer with us. I want to see how they will continue with his name in court. Because if you want to continue saying that Honorable Alan Siwanyana should continue in these proceedings, you may not fail to make mention of the Honorable Ssegirinya, whose name should not appear anywhere again in this matter. So we are yet to see if the state will again continue bringing fabrications like we've already stated. We don't want them to continue with the fabrications on the name of the Honorable Ssegirinya, who is since deceased. I think he should rest in peace. But if they continue with the other Honorable and Siwanyana, then he will not rest in peace because they will continue mentioning his name, which is not supposed to be the case. You cannot sever in as far as the particulars are concerned, having stated in the parent case that they used to sit together and plan or and finance or do whatever that they are alleging. I want to see how they remain with the Honorable Ssegirinya in this court. We are yet to see, but I will not be surprised. They have done a lot of things that surprise us. It will not be the first time, so we are ready. We are ready. Disclosures were since concluded. The Honorable Ssegirinya died without any evidence against him. He was meant to come here, we were meant to come here, but even upon closure of the matter and disclosures, there was no evidence whatsoever. The only piece of evidence that they have been clinging on is statements from co-accused persons who have been consistent. They have even now made applications. They are consistent. They have never been financed or instructed by the Honorable Ssegirinya. I want to see if they want to continue even in his death to claim that the co-accused persons, the Selwadamites and others, are the ones who are going to be witnesses against a dead person. Because if they are to provide any evidence in this matter, in the style of the disclosures that were made, because now look here, if you amend the indictment, it means you are going to amend. Are you going to amend the evidence? Because we looked at the statements which they brought in disclosures, even the witnesses, purported witnesses, were mentioning two names. So now we are going to amend the indictment. Does the state have the chance of amending the evidence? That I think that will not be possible, and that shows that we do not think they have a good case. It is dead. It was dead on arrival. It is dead now, and the case will be dead even tomorrow.
First of all, the public for being with us in all these situations, from prisons up to now. And secondly, I would like also to thank my lawyers for being there with us until up to this day. When my co-accused, the Honorable Ssegirinya, is not around, is now a dead person, the state still insists on this case. But of course, for us, we know as people who are in this case that there is no evidence against us, and we have never participated in anything to do with the murdering of people in Greater Masaka. And that is what Honorable Ssegirinya died knowing. He was a person of good morals, as evidenced by the government itself after his death. He was praised by Parliament, he was praised by government, and even during the by-elections of Kawempe North, we saw even other government officials at a rally praising the Honorable Ssegirinya, even to an extent of supporting his family after death. So we think that they know what they are doing, they know what they have done. In the best way possible is to at least try and save face of government and drop these cases, not to further hurt. Thank you.
No, on that one, there is a very clear contradiction. In court, you are accusing someone of being a murderer. When he was laying in state, the state gave the Honorable Ssegirinya an official burial. So is the state telling us that they can give a murderer an official burial? You had the communication from government when he was laid before Parliament. It was clear that the Honorable Ssegirinya was an exceptional leader. So there is a contradiction here. In Parliament, he was exceptional. Then we come to court, they are saying he's a murderer. So there is a contradiction here. We do not believe that the state actually believes that it can sustain, that it has a case against the Honorable Ssegirinya before this court. That contradiction alone, I believe, literally the background against which the state should withdraw the charges fully.